And we have giving the presentation today Thomas Moore. He's a lawyer here at the Royse law firm. He is a litigator, and he has litigated in all areas of intellectual property: trade secret, copyright, trademark, and patent. He represents the Electronic Frontier Association and has a lot of experience litigating licenses. So I just want to let those of you who are on the webinar know that we have a dialog box on your screen that you can see down on the bottom. It says questions. If you have questions, you can type them in and we can take them. And I also want to let you know that we are recording this webinar. It will be posted up on the PABA website, so you'll be able to refer to it later. So with that, Thomas, I think I'll let you go ahead and take it away.
Yes, actually I go by Tom, only my mother calls me Thomas. So we'll start with that. I first walked into Palo Alto as a lawyer in 1984, so I've been practicing over 30 years here, the last 2 of which I've been practicing very happily here at the Royse law firm. I have given seminars in the past. One of the criticisms that I've gotten is that I always start my seminars way back in time at the dawn of man. Today, however, if I can get the PowerPoint to work properly, you will see that I am starting with something else, and we are not working properly.
Page down to do it.
Try this. Nope. Today we're starting with dinosaurs. That is not supposed to represent a litigator. I put it up because it's from Jurassic Park. If you've seen the movie, you know there's a character played by Jeff Goldblum who does a lot of talking, and one of the things he talks about is what is known as the law of unexpected consequences. And the way that law works is that in any complex system, if you change a single variable, even with good intentions, unexpected things can happen. A license agreement represents the intersection between contract law and intellectual property law. The law of contract is very straightforward. No one understands it. The law of intellectual property adds further complexity, and so you have a complicated situation almost at the get-go. What I aim to do today in terms of what licensing lawyers need to know about litigation really gets into situations where the words of the contract, the party's intent, somehow go wayward in the hands of litigators. It's concepts that either go beyond or around or through the license agreements, disputes where license agreements are central, but that the result was not exactly what is intended. So I'm going to start with basic contract interpretation, contract law and contract interpretation. And as it happens, I received an email from a former colleague who said this: I can't imagine what a litigator might know about contract law other than how to best persuade the trier of fact to misconstrue the party's intent. I actually do not disagree with that statement. The only part I disagree with is that not knowing about contract law, as I said, is not limited to litigators. No one understands contract law. But there are rules, the basic rules of contract interpretation. This is what we rattle out in court, that you're supposed to give effect to the mutual intention of the parties as it existed at the time of contracting, that the whole of a contract is to be taken together, and that you are to make it or give it an interpretation so that it is lawful, operative, definite, reasonable, and capable of being carried into effect. All of that is California law. There is also a nuance which is unique to license agreements, and that is that it is the copyright holder, or really more broadly the intellectual property holder, bears the burden of proving that a defendant, an infringing defendant's conduct was unauthorized. That means that the burden of proof on interpretation does tend to fall on the copyright holder. Then there's the infamous rules for admission of extrinsic evidence. A different colleague mentioned, well, we're in California, anything is fair game. They always admit extrinsic evidence, and this is the key case, PG&E versus Thomas Drage and Rigging Company. And it's an older case, 1968, and the idea was to make clear that the determination of the meaning of a written instrument to its four corners is not necessarily what one should do, because it is the intention of the parties, well, that approaching it from the point of view that the language is clear gives a degree of verbal precision to the language which is just not there. Now, I've been litigating a long time, and I will tell you that the California Supreme Court is the only court that follows that rule. All lower courts, federal courts as well, will give meaning what they think is the clear and unambiguous meaning of particular contract phrases, and the result is often an interpretation that neither of the two parties intended at the time of contracting. But because this is about license agreements, there is one area particularly that license agreements are particularly susceptible to, and that involves the advent of new technology. Those of you fluent in Walt Disney films would recognize this as a character from Lady and the Tramp. And in fact, that is the character that was voiced by the singer Peggy Lee. It turns out that in something like 1953, Peggy Lee entered into a contract with Disney to supply the voice for that character, something like 6 of the songs and various other things, for which Disney paid her $3,500. Yes, there's some smiles from the audience. Years later, she did have a carve-out, and that carve-out applied to phonograph records and transcriptions. Insofar as people were aware, transcriptions at the time would have referred to paper sheet music. So here's the clause, 1952 contract, phonograph recordings and or transcriptions for sale to the public. And along came video cassettes. Disney discovered that all of their old movies were gold mines. They sold something like $90 million worth of Lady and the Tramp. And Peggy Lee showed up and said, those are transcriptions. And so it went to trial. So far as I can tell, and this is from press reports only, she won $3.5 million. A lot of that was sympathy factor. She was in a wheelchair. Disney had paid her $3,500, and Disney was sitting on $90 million of almost pure profit. And there the case drops off the map, frankly. It sounds like it must have been settled while an appeal was pending, something like that. But, and it also presupposes that the jury, in its wisdom, found that transcriptions included videotapes. But that's not necessarily the case. When you think in terms of the mutual intention of the parties at the time of contracting, any disruptive technology can change the party's intent. There is certainly a theory out there that the parties cannot intend in a license agreement entered into in 1952 to cover technology that wasn't even considered at the time of contracting. Now, I'll tell you honestly that I've been thinking about this case hard and sort of flipping back and forth in terms of, what is the right answer. And sometimes I end up on the Peggy Lee side, sometimes I'm on the Disney side. To me, at least, there is some merit to the idea that if the parties could not have intended something, that it could not have been subject to the contract, assuming that the contract itself does not have a clear allocation of risk in terms of the new technologies. There are other cases out there, by the way, one brought by Irving Berlin Company, where Disney prevailed. It very much depended on what the language of the contract was. It's interesting that none of the courts simply said, no meeting of the minds, no contract. In each case, they took the contract essentially as a given, rather than going back to the basic understanding of what a contract really about. To show you the influence of the judicial proclivity towards finding a contract, I'll show you this. This is actually from a case of mine. It's a limitation of liability clause. I was representing a defendant who had been accused of breaching a license agreement. The defendant filed a cross-complaint also for breach of contract. The original plaintiff then pulled out this clause and said, wait a minute, there's a limitation of liability clause. But what they were really saying, and the only way to deal with something like this is to define the subject, the verb, and the object. So look what it really says up at the top there. Licensor, that would be our plaintiff, shall not be liable to licensee for any direct damages arising out of any cause of action relating to this agreement. No damages for breach of contract is what that's saying. But a contract has to be enforceable in both directions for it to be a contract. That is what contracting means. So, this particular licensor had 500 of these license agreements out there. And the fact is that a result that there was no license agreement would have been quite harmful, not only for their case against my client, but to all the licensees out there would have had a field day, frankly. So I did argue that the contract had to be operative, definite, reasonable, and capable of being carried into effect. And so the judge, in his wisdom, limited the scope of that limitation of liability clause to the or based on making, using, selling products that implement the proprietary information. That was not the party's intent, but that is the sort of bias, if you will, that judges show when they construe agreements. It also tends to show an aspect of license agreements. I mean, an intellectual property right is a limited monopoly over a given thing. It could be an invention, a trade secret, an artistic work. Sometimes that little mini monopoly causes the intellectual property right holder to overreach. And one of the things that you'll find as I go through this are situations where the real difficulty comes from that effort to overreach. So let's get into some law that is unique to license agreements. If this PowerPoint presentation were working properly, I would have those two trains come flying in properly, but you know, technology is its own thing. You can tell I've been dealing with technology a long time because this really is not bothering me that much. When a license agreement is breached, there are really two potential causes of action. One is breach of contract, of course, and the other is an infringement case against the former licensee for infringing the copyright or what have you. But it turns out that whether a term is a covenant or whether it is a condition actually is what is determinative as to whether it is a mere breach of contract case, which is true of covenants, or in fact a condition case. Now the reason why I have toy trains there, and you aficionados will no doubt recognize Thomas the Tank Engine on the left, smiling happily, is because the Jacobson versus Katzer case is about toy trains. It involved software that was designed to operate a complicated toy train setup. And it was the software was put together by a hobbyist who was very pleased with his work and put it out on an open source basis with an open source license with the proviso that you're free to use it free of charge, but if you do bundle it into your own software, you have to say, you have to give me credit. You have to have a little splash page that gives me credit. Well, so on the right, we have a Grumpy Tank Engine, because Grumpy Tank Engines exist. And this particular Grumpy Tank Engine incorporated this open source software, bundled it into a commercial, a for-pay set of software, without giving the requisite credit to the original software programmer. This particular case caused quite a fuss. It was really the first and one of the few times that an open source license had been litigated. The trial court pretty much said, you know, that which is free, there are no damages, it's a contract situation, you want breach of contract, you can get breach of contract, but there's no damages, so you're out of court. Federal Circuit reversed. What the Federal Circuit held was that, and this explains the difference between covenants and conditions, was that the important words provided that were a part of the open source license agreement, so that the actual part of the license grant was to give credit to that software programmer. The Federal Circuit reversed, sent it back down. That case ultimately settled, is my understanding. But it did open up this covenants versus conditions idea. Now, I'll tell you, you know, we are in the Ninth Circuit, and the Ninth Circuit plays with better toys and plays better games, which brings us to the world of Warcraft. MDY Industries versus Blizzard Entertainment. This is also a conditions versus covenants case. World of Warcraft is an online user game. I have two sons who are experts. I know next to nothing about it. It turns out, though, that one of the original World of Warcraft programmers figured out that he could automate the early stages of play so that you didn't have to mess around with the character, I guess, fighting little characters. You could just automate the early parts, and the next thing you know, you're up several levels, and that's when you could take over and automate it. There was, in World of Warcraft's terms of use, a no bots provision. And so they tried to sue the maker of this automation program for contributory infringement of copyright because it violated the terms of use. Ninth Circuit said no, which was interesting. Because the bots didn't do anything but play the game. It did not modify the game, didn't alter the game in any way. What the users who were using the bots were doing wasn't copyright infringement. There was no copying involved. And because there was no copying, there was no copyright infringement. And so it was a covenant and not a condition in that particular case. I'm sure you can discern that, these two cases, they are not terribly consistent with each other, and it's an area that is ripe for further litigation. But in terms of the license agreements itself, now was actually the case with World of Warcraft. They did draft their terms of use the same way that the toy train guide did, and yet they got a different result. And that brings us actually to, because this concept of the influence a license agreement can have on the presence or absence of copyright infringement cases is hotly litigated in a similar context, and that gets into reach. And I have 3 cases represented there. The first is Berner versus Autodesk. And by reach, when a license agreement is breached, one does think of the breaching party as being the party liable. But when a breached license agreement results in a copyright infringement claim, that copyright infringement can actually reach out to subsequent users, subsequent holders or copiers of the thing in question. So in Werner versus Autodesk, Autodesk manufactured, as I understand it, it was complicated and expensive design software. They sold it to an architecture firm up in the North Counties, Marin or somewhere. The architecture firm didn't need it anymore and sold their copy of Autodesk software to a guy named Werner, who promptly put it up on eBay. Autodesk then sent a takedown notice, take it down, that's not an authorized copy, and Werner sued for declaratory relief, saying essentially that the first sale doctrine applied to that circumstance. Now, first sale is the notion that upon the first sale of something covered by an intellectual property right, patent or copyright, that the patentee, copyright holder then exhausts his right to royalties, that from then on, the item enters into commerce and can be exchanged. That is why I own a car with, Michelin tires. I can sell my car without paying a royalty to Michelin for the patent that they hold on the tires. That's what first sale is all about. Werner versus Autodesk held that it wasn't a sale from Autodesk to the architecture firm, that the restrictions on transfer in the license agreement applied, that they were conditions, not covenants, and that as such, the copyright infringement could reach Werner. And in that case, and if there's any part that's controversial, the Ninth Circuit held that there are 3 elements to a license. One is that the word license be used. The second is that there be restrictions on transfer. And the third is that there be restrictions on use. Some of us traditionalists were also of the opinion that there also had to be a right of return. And in fact, the district court held that because Autodesk never got its software back, that it was a sale and not a license. But the Ninth Circuit, in its wisdom, reversed. Which brings us to Wiley, Kurt Sang versus John Wiley and Sons. This is a U.S. Supreme Court case, which many view as throwing Werner versus Autodesk into some dispute right now. That is actually a book case. You're not going to get many book cases out of me today, but that's a book case. John Wiley and Sons do scholastic textbooks. Kurt Sang discovered that a Wiley textbook here in the United States costs $50. In his native Thailand, they cost $20. Being an enterprising youth, he got his friends and relatives to buy up all the Thailand-based textbooks they could get their hands on, and he then sold them in the United States for something like $30. Wiley said, no, you can't do that. Part of our copyright right has to do with importing, the ability to import goods into the United States. And the Supreme Court said, no, the first sale doctrine is preeminent. That once the sale is made abroad, you've exhausted your right to royalties. People can bring books into the United States. So if any of you have ever bought a book at Heathrow and brought it into the United States, you'll be pleased to learn you are not infringing anybody's copyright. Apparently that's something Justice Breyer, who wrote the decision, has done more than once, so he also exonerated himself. So that puts things, as I said, this is a very unsettled area of law. I've got Lexmark there because that case is now pending. There was a decision by the Federal Circuit, a 3-judge panel of the Federal Circuit that went in one direction in that case. The Federal Circuit then sua sponte decided to hear it en banc, which is not a usual circumstance. So what Lexmark is up to, they're the printer guys, printers, copiers, things of that nature. We all know people do not make the money on the hardware, they make their money on the ink. It turns out that Lexmark has a business model now where they will either sell you one of their ink cartridges outright, or you can do sell it, they'll let you have it on a return it to them basis, which is slightly less expensive. If you do the return it to them basis, then you do return it to them. They refill it with their own ink and charge you for the ink. It's more likely than not where they make most of their money. Well, it occurred to people, I understand primarily in Europe, that these return cartridges, they could be fixed in a way so as not to be return cartridges anymore. Purchased inexpensively in that fashion and then filled up with ink. And so there again, you've got a first sale situation. The Federal Circuit is interested in re-examining their prior holdings with respect to import. That's primarily what they're interested in, what they are going to do with that case. But it's a very interesting case. As I mentioned, you know what's really going on. They have a patent in the cartridge. They either do or do not have a patent in the ink, but other ink will work just as well. And what they're essentially doing is tying the two concepts together, which brings us to the next topic. I hope it's the next topic, but yes, misuse. This is another concept we litigators use that is outside the scope of the license agreement itself. There are two different kinds of, well, the basic concept is up at the top of the slide, which is that courts may appropriately withhold their aid to an IP-owning plaintiff where the plaintiff is using the right asserted contrary to the public interest. Historically, that involved anti-competitive behavior, not unlike what Lexmark is up to, though because Lexmark gives you an option to go with their program or not with their program, it probably isn't anti-competitive. But they knew they were walking right up to the door. Misuse also applies, though, where a provision in a license agreement is deemed to be contrary to the constitutional policy of promoting progress of the science or of the useful arts. So that is why I pulled up The Emperor's New Groove. And yes, I may be picking on Disney today. And that's, they're just involved in a lot of these. The Emperor's New Groove is reputedly the worst Disney animated movie ever made. I do not know myself because, of course, I didn't see it. I'm not sure the animator's mother saw it. It was in and out of theaters quickly. Now, if you were the kind who wrote movie blogs, you might be interested in licensing the trailer to Emperor's New Groove to put it on your blog site and in order to rip into just how disjointed and the like that movie reputedly was. Yeah, I haven't seen it. If you had entered into a license agreement with Disney, you would have found a term in the license agreement that the website in which the trailers are used may not be derogatory to or critical of the entertainment industry or of Disney or of the motion picture that you are getting the trailer to. This was, that clause was put forward as an example of misuse in the case of Video Pipeline versus Buena Vista Home Entertainment. The Third Circuit held that that was not misuse. That was not misuse, but it certainly walked up to the edge. And in my view, it is misuse, in that both art and art criticism go together, and that telling people they cannot license a movie trailer subject to only saying nice things about it does seem to me, at least, to be contrary to the copyright laws. Now, as it happens, the court mentioned that there was a fair use exception that could apply to this situation, which would relieve you of having to license the trailer in the first place. But it's an interesting case, and it shows just how these things can end up being litigated. Now, next up is another concept where the license agreement itself is possibly not going to contain what's really going to happen, and that's the notion of perpetuity. I have a toy Spider-Man shown there because that's a toy Spider-Man case. It turns out that Mr. Kimball, in the case of Kimball versus Marvel Enterprises, had patented a Spider-Man toy that essentially shot little webbing. It was like a silly string web shooter. Years ago, he got into a dispute with Marvel over that thing, gave them a patent license. The patent license had no mention of time. It was basically, Marvel, you pay me 2% royalties on your sales of this webbing Spider-Man web product, and for as long as you keep making new Spider-Man movies, which promises to be forever. Apparently, Marvel, shortly after entering into that contract, discovered a Supreme Court case which said that patent licenses only survive up to the expiration of the patent. And much to Marvel's delight, they stopped paying the moment the patent expired. And Kimball went and took it to the U.S. Supreme Court to see if that old precedent is still good precedent, and the answer is yes. Yes, the Supreme Court said, you know, that's just not a rule we feel like changing. Stare decisis means something in our system, and we're gonna stick to our guns. Now, part of why I'm including this here is because Justice Kagan, who wrote a very witty decision, threw out some alternatives as to how you might get those royalties to go beyond the length of the patent. Now, I'm mentioning patents here in particular because copyrights last almost forever. Copyrights are now life of the artist plus 90, which means that the songs that Irving Berlin wrote in the 1920s will not expire. He lived to about 100, died in the late 60s, early 70s. So those copyrights are going to go well into the next century. But patents are a mere 20 years by comparison. So just as Kagan suggested that the licensee could pay its own equal to 10% of the sales during the patent term, but you could amortize it beyond the patent term, which actually is kind of a nifty idea. One could also come up with post-expiration royalties, so long as it is tied to a non-patent right. Often trade secrets and patents are licensed together. Trade secrets potentially can last forever. They last as long as the secret remains secret. Or her third possibility is that you could form a joint venture, which of course could be perpetual. And I'm sure just what Mr. Kimball and what Marvel needed was to be in a joint venture where they were fiduciaries of each other. And so I put a little picture there of somebody's perpetual motion invention because this is where I want to take it back to California law, to state law. And that is that if you are thinking about something that's perpetual in form, you need to remember that courts don't like perpetual agreements. They will do everything they can to not construe a contract into perpetuity unless, as this case says, compelled by the unequivocal language of the contract. My impression, and I was hoping to find a case, is that if you use the word forever, forever means for a reasonable time, and indeed not forever. So, we need to get rid of that. Yeah, here we go. All right, which largely brings us to the end of my prepared presentation. So what should licensing lawyers know about litigation? What I've tried to do really is I covered a lot of topics, most of which are very complex. And I did that as a way of showing you that when one is drafting a license agreement, you are not going to be able to anticipate everything that we litigators might end up doing with your wonderfully drafted license agreement. I did at one point litigate. I called it at the time the Winchester Mystery House of license agreements. Just like Winchester Mystery House, there were clauses that led nowhere. There were defined terms that was defined differently in different places. The thing was 175 pages long. It had nearly between 100 and 200 defined terms. There was a glossary of defined terms in the front in 2 places, and then a smattering of defined terms in the body of the contract itself. It also had similar terms defined in 2 different places, slightly differently. And what I was arguing, of course, is no one can make sense of this agreement. It could mean anything. And it was extremely difficult to explain to the judge. And so I say there, keep it simple. The real audience for a license agreement, and this is from a litigator's perspective, is ultimately going to be a judge. And while judges can parse complicated sentences, they get their own ideas when they start doing that, particularly when the sentence is in excess of 100 words. And so really the upshot is that it's much easier for your friendly neighborhood litigator to litigate a license agreement that everyone can read and understand than it is to deal with one that is exceedingly complex. Now, in that particular case, the original license was written by a committee. That committee then disbanded, and the license agreement was added to over the years by different committees. And that's how you got the mess, and no one bothered to restate it. So that is that's the upshot of all of this, and it has been I've been very pleased to share some of these ideas with you, and be happy to address any questions that you might have.
Okay, thanks, Tom. So, any questions here or online?
Well, in the license, I was always taught that anything not expressly granted is reserved. You know, in other words, in terms of bundles of rights, copyright, and the other sort of intellectual property rights. Has there ever been any litigation on that? Because you know, I've always taken very comfortable license rights, because if you don't cover it, you don't get it.
And that's right. I mean, and that's right. People it's still construed that way. Part of what I attempted to show is that there's no guarantees, and what's going to happen is the judge is going to construe what he or she regards as the plain language of the agreement. But that's what you just said, Fred. That's essentially correct.
So what lessons can we get from that? I mean, basically, it's like a random shoot.
And it is. That may be the lesson. And in fact, that is the lesson. The lesson is, you know, if you keep things simple and straightforward, some of the problems that have come up, I mean, you do not want to put your client into a misuse situation, though they will want to be in a misuse situation. You know, it's, gosh, you know, we're selling all of this patented stuff, but we've got this stuff over here. How can we tie the things together? Or like that limitation of damages language. You know, it's of course the client doesn't want to be sued for damages. Of course he doesn't. So, you know, come on, put a clause in. So yeah, if there's a theme to this, simpler is better. And that I almost want you to not work on anticipating some of the things that might happen. I remember one situation, and this is in an employment context, where the California Supreme Court held that employment agreements can be unconscionable under certain circumstances. So right away, an employment lawyer stuck into an employment contract, and you agree this is not unconscionable. That is the sort of thing that needs to be worked through. That plus, you know, the judge is the audience. The judge is the audience, and a lot of odd things can happen. Change of technology, good thing to anticipate changes in technology, but there's a limit to that.
Like now and forever throughout the universe.
Exactly. Exactly.
So, Tom, the problem I've seen several times is where a client comes in with a very clear contract clause, but neither one of the parties has been following the clause.
Oh yes.
So
what happens there?
I mean, is there a drafting Well,
I mean, that happens all the time, and the reason, and I end up litigating that all the time. I mean, and there's two ways for it to go. One is to take the position that the way the parties performed is, in fact, what the parties intended in the first place. There is a rule of law that says that the parties' performance post-contracting pre-dispute is to be given a high degree of credence in terms of interpreting the contract. But usually they just go off on their own. And frankly, it ends up where, again, with unanticipated consequences. I certainly had a case recently, and that was in a very complicated agreement. It was had to do with it was a VC agreement. 50 pages, lots of defined terms. And yes, they just did what they were used to doing. But because and what they wanted to do was get money back from my client, because they didn't do what the contract said, they couldn't enforce it. So sometimes that is the result that happens.
I mean, my take, I don't know if you agree with this, but it's just completely unpredictable if you litigate a clause that neither party is fault.
Well, that's kind of right. The thing I tell people is I'm a handicapper. Just as at a horse track, I can say to a client, you've got a good case. It's like saying you've got a good horse. That doesn't mean the horse is going to win. I can give you the odds, and then the judges come into the mix. If it reaches a jury trial, the jury comes into the mix, and a lot of things happen. I could certainly go from there to promoting the notion of settling cases. I mean, don't get me wrong, I try cases all the time, but trying cases, it's always a coin toss. Yeah.
What's your feeling on more inclusive technology provision? Like if you took the Peggy Lee and instead of having transcripts, it was you can't reproduce this.
Yes, the thing about Peggy Lee was that there is an actual carve-out, and that was a little bit unusual. The Irving Berlin case, the reference was to motion pictures, and motion pictures, the court was prepared to say that they could sit on a bunch of different kinds of media. Where the allocation of risk for a change in technology is reasonably clear. Again, I'm a handicapper, but my best guess is it'll be enforced, so long as your plaintiff doesn't show up in a wheelchair having been paid $3,500.
So, Tom, what I always wonder is I look at some of these agreements, licensing and otherwise, just generally that guys like Fred and me put together and negotiate, and it takes us several months, and it's complex. And even when we go back and read them a year or two later, it's really heavy going. And I oftentimes wonder, God, I wonder if a judge is ever going to understand this and what's going to happen when you get into court, especially here in California, because we kind of have a reputation here in California to be a little more activist. Is there something to that? I like the idea of keeping it simple, because it seems the more complex it is, the more it can be misinterpreted.
Judges are inclined to take their own reading of the contract, and you're never going to find a case that says that. I mean, this is the voice of experience, and that goes right up to the courts of appeal. And the problem then becomes, the judge can land almost anywhere, and so the more words you have. I am not against defined terms, by the way. I am heartily in favor of defining terms. But if you've got a sentence of more than 100 words, the judge is not going to be able to pull out the subject, the verb, and the object. I heard once of a release And you can have a lot of fun with releases. The party of the first part on behalf of its heirs, assigns, lawyers, cousins, nieces, next door neighbors, hereby fully and completely and forever, releases, waves, on and on and on. And the more of that you do, the harder it is to read. And sometimes, you get the feeling judges just get impatient and will glom on to the simplest answer in a complicated agreement.
By the way, if you're tweeting, use hashtag pop-up. Do you have a Twitter handle, Tom?
I do not.
Okay, that's it.
I have many things. I am not a Twitter.
Hey, Tom, one other issue that is in the intersection of tax and licensing is that when you do these global deals between countries where there's no international tax treaty, a lot of times the licensees want to recharacterize the license as a right to purchase a copy because they don't want to pay that 30% withholding tax. And I mean, based on what you said, I mean, it's just good common sense. You're trying to balance for the tax authorities in the licensee's country to make it look like a sale. But the more that you do, the more it looks like a first sale, which means that the licensor, if they're our client, are going to lose some ability to control the further distribution of that software.
Yeah, Fred, that is exactly right. That is exactly right. I've certainly seen contracts, license agreements among them that focus on things like the international tax ideas to the exclusion of everything else. A judge is going to read it straight. The judge is going to read it straight. The judge is not going to take as an argument, oh, but you don't understand. Japan, I think it is Japan, imposes a tax of 30% on licenses. And they will not buy that. They will not buy that. For one thing, it's outside the four corners of the agreement. And again, they tend to take, they may listen to your evidence. One person says one thing, the other person says something else in terms of what the intent was at the time of contracting. They're going to make up their own mind as to what the word.
Well, speaking of Twitter, I had a question about end-user agreements.
Okay.
So, with consumers are really worried, especially, I think in Twitter, in their terms of use, they say, you own your data, you own the right to everything you're saying, but we have the right to use it however we see fit in any type of technology not yet contemplated. That's actually in lots of end-user agreements.
Okay.
Is there any argument about maybe that would be anti-public policy in terms of the privacy law aspect?
I cannot think.
Is it so exponentially
Yes,
broad?
I know it is. Terms of use agreements are controversial because first, are they contracts in the first place? And the trend is that they are. As contracts, are they adhesion contracts or unconscionable? That really has not been litigated to any great degree. And even if you get past that, what are the reciprocal obligations? California, and just about every state, but California in particular, imposes an obligation of good faith on any terms, so that even if Twitter reserved the right to do that, they would have to exercise that right in a good faith manner, in a way that does not deprive their Twitter users of their reasonable expectations under the agreement. Now, whether that is the law or not the law, I will be in an oral argument in the next 8 weeks or so, arguing that very thing. I'll let you know how that turns out. But it's one of the things about terms of use, and in my case is unusual, is that they don't get litigated. They don't get litigated. So YouTube has a very strict non-commercial use policy now. I mean, come on, they have Beyonce videos on YouTube. How are those non-commercial? But technically, it's non-commercial. So if YouTube breaches its terms of use, more or less automatically, the damages involved are very small. And that's why we have not seen a great deal of litigation in the consumer arena. But as my the first thing is, it will be treated as a contract. That more likely than not, that tends to be the trend. Click-throughs work. No one is litigated whether just reading a website makes you have to adhere to that little tiny terms of use button down in the lower left-hand corner. For those of you who draft terms of use, the same thing, just keep it simple, geez. Let the users have that which is the user's, keep that which is yours. Otherwise, you know, somebody will jump in.
Okay. All right, we're pretty close to the top of the hour here. I'm going to go ahead and please conclude the webinar portion of this. I think, Tom, you'll probably stick around, right? If you have additional questions. Excuse me. Well, thanks for being here. Thanks for doing this. Thank all of you for attending. And our next event, as we said for Bob, is September 28th, right? Domestic violence. And where is that at, Gretchen?
That's at Comerica Bank in downtown Palo Alto.
Comerica Bank, and then October 1, we'll be right back here with the Bridge the Gap series for the solo and small firm section.